The Frontline presents, what does the John Lewis Voting Rights Advancement Act, also known as HR4, do? Part 2, Preclearance Reinstatement. HR4 will reinstate federal preclearance requirement for any changes in election procedures in any states that have had 15 or more voting rights violations in the last 25 years, 10 or more voting rights violations in the last 25 years, with at least one being committed by the state itself, and any subdivision with 3 or more voting rights violations. Federal preclearance will be required when there has been any alteration that reduces the amount of or changes the distribution of multilingual voting materials, unless a similar alteration occurs in the English voting materials for an election. Preclearance will be required when there has been any change that would reduce, relocate, or consolidate voting locations, including early, absentee, and election day voting, or reduction in the number of days or hours of early voting on Sundays. Federal preclearance will be required when there has been any change to election policy that adds a new reason or implements a new process to remove a person from a voter roll. Preclearance will be required when there has been any state or subdivision that has either 2 or more racial or language minorities that each represent 20% or more of the voting age population, or a single language minority that represents 20% or more of the voting age population on Native American lands that are located entirely or partially in the state subdivision before implementing changes to the number of seats that are elected. Conversion of 1 or more seats from a single member district to 1 or more at-large districts or to multi-member districts, and any change or series of changes to the boundaries of a jurisdiction that reduces the voting age population by 3 or more percentage points. Federal preclearance will be required when there has been any states that have already met the requirements for federal preclearance under the new formula before implementing new procedures under the new covered practices. And states that are covered should seek approval from a 3-judge panel or the Attorney General. Any appeals of either of these are allowed to go to the Supreme Court.